Good evening, everyone. Peace and blessings to you. This is Tamara T. Bush coming to you with some additional discussions to help you to obtain clarity on consumer law. And so this is going to be a continuation of yesterday's broadcast where we are going through the FDCPA, the Fair Debt Collection Practices Act. And so this is going to be 15 USC 1692. And this law you can actually find on the Cornell Law website, which is also the Legal Information Institute. You can look up these laws, you can Google them. The first thing that's going to come up in your search is going to be Cornell Law. It's going to be at the top of your search bar, or your search page rather. So if you do not know who I am, my name is Tamara T. Bush. If you are new to me, just know that I'm here to just help provide clarity. I am not an attorney, nor am I providing legal advice. I just wanted to put that out there. I am just providing clarity on these laws as I understand them. And I want to, help people to gain clarity so that we can know exactly what our rights are and how we're being violated every single day, because it's important that we know these things to know how to properly assert ourselves, right, and go after these companies and hold them accountable and get our remedy when they violate us, right? So let's go ahead and get started. I'm going to go ahead and share my screen. I'm super excited to have you all here with me this evening. Before I share my screen, I just wanted to say, please go ahead and share this broadcast out to anyone that you believe is going to benefit from this information. If you have someone that is in a situation that they're trying to figure out, exactly what they're trying to do, definitely share this information because it is most beneficial. I'm just going to go ahead and share this broadcast out to make sure that those that I would like to see this can go ahead and see this. So if you all allow me just a moment for me to go ahead and do that, that would be greatly appreciated. 1 second. Let's see. So there. And also going to make sure that we share it there. All right, I think we are good to go for the most part. So if you can see me, if you can hear me, definitely go ahead and place a 1 in the chat. I want to make sure that you all can see me and that you can hear me. Because I think this session this evening is going to be a good one. Some of us are dealing with, we receive letters, we receive phone calls, and even though, we think that there are certain guidelines that collectors must follow in order to be able to contact us or collect from us or communicate from us, I'm here to tell you that you are in complete control of that situation. So I'm going to tell you why. And let me just go ahead and share my screen. All right, place a 2 in the chat if you can see my screen, if it's clear. I want to make sure that everyone can see my screen. And I'm checking on Facebook too, just to make sure that my screen is visible, because we don't want to have any more technical difficulties. Right, okay, so this is the FDCPA, which is U.S. Code Title 15, Chapter 41, Subchapter 5, which is 1692, and this is going to be Section C. Now, yesterday, we went over the FDCPA 1692, Congressional Findings and Declaration of Purpose, along with a few definitions, and then we actually covered acquisition of location information. So I'm going to just provide a brief summary of what we covered yesterday. So we went over the definition of what a debt is, and I put emphasis on any obligation alleged, any obligation or alleged obligation of a consumer to pay money, right? I did a strong emphasis on alleged obligation. And I did emphasize to you that or means that you have the right to choose. And the right to choose is your choice. It's not the creditor or debt collector's choice if you pay. It is your choice if you have, if you choose to pay the debt or the alleged debt that they're supposedly saying that you owe, right? We also went over the fact that debt collectors cannot state that such consumer owes any debt. And when you click on the word state, it's not saying that they cannot verbally state that you do not owe the debt. When they're speaking of this particular word in the FDCPA, this is actually talking about jurisdiction. And so that is where we're getting into the jurisdiction of the courts and how they're able to, quote unquote, preside over any claims that are submitted under what they call to be their house, right? Number 3, we went over that debt collectors cannot communicate with any such person more than once. So if you all remember, I specifically stated that you have the right to state to a debt collector if they have permission to communicate with you, or if they do not have the permission to communicate with you. And so debt collectors are in the business of taking liberties, right? So they violate your rights by contacting you at their leisure on their schedule and as they see fit in order to satisfy their agenda and what they have in trying to collect debt from you. And so today we're going to sort of flip that a little bit, because I'm going to give you some information that's going to show you how you are in control when a debt collector contacts you. You're in control of how they contact you, when they contact you, and under what conditions they contact. We also went over that debt collectors cannot communicate with you via postcard. A postcard is typically a piece of mail that is not enclosed, right? It's not an envelope. It's just a regular, it's just like a regular piece of mail, right? And so you can see what's on the back, what's on the front, and you can see the contents of that correspondence, right? And so what did we say? We said that they cannot communicate with you via postcard because that is a violation of your privacy, because whomever is handling your mail can see that you are doing business with a particular company, right? That is a violation of your privacy. And then also, if you live with people, if you have roommates, it's a violation of your privacy. Let's say you leave a piece of mail out on the table, they can see who you are conducting business with, and that is a violation of your privacy and a violation of your consumer, okay? Number 5, we said that they cannot use any language or symbol on any envelope or in the contents of any communication affected by the mails. And so yesterday I pulled up an example, right, of what that would look like. So it says any language or symbol. And so I use Target as an example. When you receive a piece of mail from Target, that's a billing statement for a potential credit card that you have with them, they use their language and they use their symbol on those communications, be it on the outside of the envelope or on the envelope that is inside, or on the contents that is on the inside of that envelope. Either way, they are breaking the law because they are not supposed to use any language or any symbol on any envelope or in the contents of any communication affected by the mails or telegram that indicates that the debt collector is in the debt collection business, right? And so those are some of the things that we went over, and we pointed out the fact that we're literally being violated every day and we don't know. We believe that we're supposed to be contacted, that this is the normal course of business, that they are entitled to send us a monthly statement, right? Which they are not, because the law says that they cannot do that. They cannot identify themselves as a debt collector with a language or a symbol, right? And so this was just basically to bring light to the fact that we're literally being violated, and we are completely clueless that we are being violated, right? So today, I want to go ahead and focus on 15 USC 1692C as in Charlie. The header for this particular subchapter is communication in connection with the debt collection. So this is going to be a really, really good one to go over because, like I stated earlier, we are bombarded with mail, we are bombarded with phone calls, we are bombarded with these LLCs and these corporations coming after us for the collection of a debt. Even if we believe it is during the normal course of business, the federal law states the terms and conditions under which they are able to communicate with us, right? So let's go ahead and get into it. And so again, I am on the Cornell Law Legal Information Institute website. You can do a search for 15 USC 1692C, and this law is going to automatically pop up communication in connection with a debt collection. Okay, let's go ahead and read it. Letter A, communication with the consumer generally. So this means in general, not under any specific circumstance, right? So what does it say? Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with a consumer in connection with the collection of any debt. Last week, we said the word any means all, so that means everything. So it doesn't matter if you have a collection agency coming after you for the collection of a debt. It doesn't mean, or it doesn't matter if you have a company that is sending you a monthly statement for the collection of a debt. Your monthly bills are in fact considered a debt, right? So the fact that they're sending you monthly bills is a violation unless you gave them explicit written or verbal consent to contact you. Now, just the fact that you went and applied for the loan or you apply for the credit card, it does not give them permission to communicate with you. That is not permission. That is a transaction. That is not the same as providing permission, right? And so this is telling us that they have to have prior consent. So if you are currently being harassed by a debt collector, or they're calling you, they're sending you letters, and you did not specifically provide them with written permission, this law says that you are being violated. And so you can notify them, hey, I didn't give you written permission. I did not give you verbal consent to contact me. You just have to let them know, right? A lot of these companies, a lot of the times they know the law, but sometimes the employees that are working behind the desks of these companies do not know the law. So the majority of the time, employees are operating off of company policies or procedures, right? They're not being taught federal law. They're just being trained by a supervisor or a manager at their job, because this is a job for them, right? So they're not studying federal law. So, you can take the time out to educate them or not over the phone when they contact you, or you can just get to writing letters and put these companies in line for violating you. Now, what does it say? Not only do they have to have prior consent of the consumer, and remember the consumer is you. Who is the consumer? The term consumer means spouse, parent, or if the consumer is a minor, guardian, executor, or administrator. That in essence is still you, or that means anyone in your household that is associated with you, right? So if they're calling my house and they're trying to speak to my husband, I can still speak on my husband's behalf, right? Or they're not going to call my son because he's a minor, but should that happen, I am a consumer on his behalf, right? So that's basically what that means. A guardian or executor or an administrator. And so that definition, if you remember when we went over the definition of a consumer from the FCRA, even though it's still the term consumer, there's different definitions depending on the situation, and there's different definitions depending on the law in which you are trying to assert yourself, right? So previously, the FCRA defined a consumer as a natural person, a living, breathing natural person. But in this situation where we're talking about debt collection, that definition is expanded to include family members or anyone else that could be potentially administering an estate, or someone that maybe has power of attorney over your affairs, or anyone that is a close associate that's being contacted, they're being contacted by a company. That company is trying to get information about you. So they've expanded on the term consumer to include the people around you that they know are going to try to contact to try to get information on you, right? So this is a good thing. So that means that other people can, sort of speak on your behalf and say, listen, you're not supposed to be calling me, so they can tell the companies not to call you, and you can also tell these companies not to call you. Now, number 1 says they can't contact you without prior consent, but it says at any unusual time or place known or which should be known to be inconvenient to the consumer. So let me ask you a question. What is an unusual time and what is an unusual place? Who decides what's unusual? Who decides that? Who do you think decides what time is unusual or what place is unusual, right? So think about it for a second. Who gets to make that decision? How does a debt collector know what is an unusual time or place for them to contact you? They don't know. Only you know. And as far as I'm concerned, any time is an unusual time or place for them to contact me. That means that I don't ever want to be contacted by a debt collector. There's no way of them knowing. There's no way of them knowing, right? Only you know. So in the absence of the knowledge of circumstances to the contrary, a debt collector shall assume that the convenient time for communicating with the consumer is after 8 o'clock or before 9 o'clock. Okay, so this means after 8 o'clock in the morning or before 9 o'clock at night. But like I said before, how will they know what's a convenient time for you to contact them? The answer is they don't know. They have no way of knowing, but they still call you. They still call you. They still send you letters without knowing. They still send you letters and they still call you without knowing. So you get to decide what's an unusual time or place for them to contact you. They don't get to decide that. And so the fact that the law states that if they don't know, they're supposed to contact you after 8 in the morning or 9 o'clock in the evening, they're operating based off of an assumption, because they will never really know what is considered an unusual time or place. All right, okay, so what does number 2 say? If a debt collector knows the consumer is represented by an attorney with respect to such debt, has knowledge of, or can readily ascertain such attorney's name and address, unless the attorney fails to respond with a reasonable period of time to communication from the debt collector, or unless an attorney contests to direct communication with the consumer. So this one right here is pretty self-explanatory. It's basically saying that if you have an attorney that is representing you, the debt collector cannot contact you, that they must contact the attorney. Okay, fair enough, fair enough, fair enough. This one right here, at the consumer's place of employment, if the debt collector knows or has reason to know that the consumer prohibits the consumer from receiving such communication. Okay, so again, if a debt collector chooses to call you at work, how are they going to know that your employer prohibits such calls? Did they do any preliminary investigation to know that it was not okay, or that it was okay to call you at work? Everything that a debt collector does is based off of an assumption. It's based off of an assumption. Just keep that in mind. It's always based off of an assumption, right? Okay, so let's get into the ceasing communication. Now, ceasing communication, that's considered to be a cease and desist, a cease and desist. If a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt except. Now, if you are going after a debt collector for a remedy, meaning you're enforcing your consumer rights. Anytime that I say remedy, just try to connect that with enforcing your consumer rights, right? Getting what is owed to you. If you notify them to cease further communication, you want to make sure that you put conditions under which you allow them to communicate with you, right? So if you just give them a blanket cease and desist and you're trying to go after a company for remedy, they're going to say, well, you told us not to speak to you, so we couldn't respond to your letter because you sent us a cease and desist. They'll use it against you, right? And that's not what you want. You want to provide a cease and desist, but you want to put conditions under which you will allow them to continue to communicate with you. And so what are some of those conditions? It outlines it here. So what does it say? They shall not communicate further with you, the consumer, except advise you that the debt collector's further efforts are being terminated, to notify the consumer that the debt collector or creditor may invoke a specified remedy. Now, invoke a specified remedy. That specified remedy could potentially be a list of demands that you've submitted to that debt collector for them to satisfy because they violated you. Because remember, once you are violated by a debt collector under the FCRA or the FDCPA, it's your job to be able to specifically advise them what you want them to do, because you have the power to tell these debt collectors what it is that you want. You have to be clear in telling them what it is that you want so that you can get all of your remedies as entitled to you under the law, right? You want everything. I'll give you an example. If you know that you want to go on and you purchased a car, you got a car loan, right? And that dealership or that financial institution failed to properly advise you of your rights during that transaction, and you choose to go after them for remedy. What are some of the things that you can ask for when you know that you've been violated? And it's a car loan. Okay, well, it's a car loan. We know that we want our car to be reflected as paid in full with a zero balance, right? You don't want to have to make any more car payments. You know that you want the title to your car free and clear. You don't want to have a lien on your title, right? And you know that you want your credit report to reflect 100% on time and accurate payments. Those are a list of demands, right? That is a specified remedy. You're asking for your remedy because you have been violated. So if you send a cease and desist to the bank that is collecting on your car note and you tell them that I am refusing to pay a debt, cease further communication with me, except to notify me that you have placed my account in a do not collect, do not pay status, and to tell me that you are going to update my credit report with 100% on-time payments. You're going to zero out my car loan to a zero balance, and you're going to send me my title free and clear. That is a specified remedy. Okay, hear what I'm saying. And remember what I said yesterday is that you have to be able to see how the law is written, but you have to also be able to identify what is not there. It doesn't tell you that you can't do that. It just says invoke a specified remedy. So literally, when you are being violated by these companies, you are in control and you have the power to tell them what you want them to do. What you want them to do. And whatever it is that you're asking for them to do is well within the confines of the law, because you are in control, you are the consumer. Okay. And so then it says, so where was I? So to notify the consumer that the debt collector or creditor may invoke the specified remedies, which are ordinarily invoked by such debt collector or creditor, or where applicable, to notify the consumer that the debt collector or creditor intends to invoke a specified remedy. If such notice from the consumer is made by mail, notification shall be complete upon receipt. So what does this mean? What does this mean? When you are going after a company for a specified remedy, this is telling us, this law, the cease communication, the section right here, is telling us that we must put these companies on notice. We have to put them on notice. Why would you put them on notice? Because you're refusing to pay a debt. You have to tell them that you refuse to pay. You have to tell them that you are wanting them to cease further communication with you, unless they are notifying you that their efforts are being terminated, i.e. they put your account in a do not collect, a do not pay status. And when you notify a debt collector that you refuse to pay a debt and you properly put them on notice, they cannot perform any adverse action against you. And we'll get into that a little bit later in the subchapter. We'll talk about adverse action. But just to get into it a little bit now, adverse action is when they accelerate your loan payment. They may close out your credit card. They may restrict your account. That is considered adverse action. They may close your account. That's adverse action, right? And so when you properly put creditors on notice, it is illegal for them to perform any adverse action against you for you exercising your consumer rights in good faith. They cannot take adverse action or discriminate against you for exercising your consumer rights in good faith, because adverse action in essence is discrimination. It's discrimination, right? We think of discrimination as something else, but when companies do things to you because of a letter that you've sent, that is discrimination and it's illegal, right? It's illegal. So if such notice from the consumer is made by mail, so what is it telling you? You have to notify a debt collector in writing through the mail. It says is made by mail, right? Because mail starts or court starts in the mail. If you're going to take a situation all the way with the debt collector where you end up in court, court starts in the mail. Yes, you can call them. You can argue with them over the phone. There's all kinds of things that you can say to these people over the phone, right? But unless you are going to take that conversation, transcribe it into text or writing, and have that available to submit with your paperwork into your court record, I don't know about you, but I'm not going to waste energy arguing with people over the phone. I'm going to send out my letter. I'm going to put some tracking on the letter so that I can make sure that that is received. And it really doesn't matter if they respond to it point by point or not. You've done what you're supposed to do, because notification shall be complete upon receipt. So notification of you advising them to cease and desist all communications except to notify me that your efforts are being terminated, to notify me that you are going to invoke my specified remedy, right? You received it. So I know that you received it because I have tracking that shows that you received it, and I included the green signature card to see that someone signed for it. So I know that you have it, right? Notification shall be complete upon receipt. That's basically what it says. Once they receive it, they got it. Your job is done. Now you move on to the next step, right? So this section right here is very, very, very important. If you have a debt collector that is calling you, start picking up the phone. Start picking up the phone. Don't be scared to pick up the phone, because now you're going to be in the discovery phase, right? Because remember, court does start in the mail, but it's also going to start on the phone call, because this is going to be evidence that you're collecting, right? So even if you don't transcribe the entire conversation of what took place or what transpired when they called you, you're still going to record names, dates, and times. Judy called me from ABC Collection Company on March the 8th at 7:26 p.m., right? You're still going to record names, dates, and times. And when a debt collector is calling you and they're saying this call is being recorded for quality assurance purposes, you say, me too. I'm also recording the call. When they call you on the phone, start asking you for your personal information, ask them for their personal information. What's your social security number? What's your date of birth? Make them feel uncomfortable, like they're trying to make you feel uncomfortable, right? You are in control as a federally protected consumer. Remember that at all times, right? Remember that at all times. And if they can continue to communicate with you after you have properly notified them of a cease and desist, that is just more ammunition for you to use against them when you go up against them for your, using your administrative process and your remedy. All right. So let's see what's next in this subsection. Harassment or abuse. Let's get into that. Harassment and abuse. Now this is a good one. This is a good one. harassment, or abuse. This is 15 U.S.C. 1692 D as in dog. The debt collector may not engage in any conduct or natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of debt. Are you not being abused when they call you? Okay, so let me back up a second. So I made a post probably the week before last, and I said that we should literally be crying crocodile tears when these companies violate us, right? Crocodile tears. We need to be dramatic, we need to be emotional, because we really need for them to understand that they are literally harassing us, they're trying to oppress us, and they're trying to abuse us in connection with the collection of a debt. You get to decide what harassment and oppression and abuse is. They do not get to decide that. They don't get to decide that. And they can't threaten you. Right? Now, what does number 1 say? The use or threat of use of violence or other criminal means to harm the physical person, reputation, property of any person. Does this not say property? Okay, so what's an example of a property? Your car. What do they do every time you don't make a payment? We're going to come and repossess your car. Isn't that a threat to harm your property? Isn't that a threat? I don't know about you, but that's a threat. And so when you threaten me, that causes me to feel oppressed and abused, right? That's violence against my property. And they may say, oh, we're going to have to report a 30-day late. That is my reputation. You are threatening my reputation, right? That's what that is. And so we're out here being abused, we're being oppressed, and all of these things, and we are just taking it because we're thinking, oh my God, I got to make this car payment. How am I going to make this car payment? How am I going to make this house payment? But there are laws in place to ensure your peace of mind, to ensure that you can continue on, and you have the right to not be violated. You have the right to not be harassed. You have the right to not be oppressed. You have the right to not be abused. This is federal law. I can't make this stuff up. This is federal law. All right, number 2, the use of obscene, or profane language or language, the natural consequence of which is to abuse the hearer or reader. Who decides what is considered obscene and profane language? You're thinking, oh my God, they said a cuss word. They said the F word. They dropped a B-bomb. We're not just talking about profanity in that sense. We're speaking about any language that any language that they said to you in either a letter or they said to you over the phone that made you feel harassed, oppressed, abused, right? That is considered obscene. So when they say that a bill is due, you're telling me something is due. That's profane language. You're telling me that you're going to give me a late payment if I don't pay by March the 10th. That's abuse. That's obscene or profane language. You get to decide what obscene and profane language is. It's not about a cuss word. It has nothing to do with a cuss word. It has everything to do with how the person relaying that information makes you feel. That is what obscene and profane language means. It's not about a cuss word. I need for you all to understand that. It is not about a cuss word. You get to decide what is obscene and profane. Hear me, okay? So I'm telling you all of this to show you that the ball is in your court. You have more control. You have more control than what you think you have. And we give these companies more control than what they actually have. We give them that control out of fear. We give them that control out of fear. All right, here's another one. This is what they cannot do, which is considered harassment or abuse. The publication of a list of consumers who allegedly refuse to pay any debts. Come on. The publication. Don't they list or publicize people that are behind on the real estate taxes? Can't you go down to the courthouse and see a list of people that are behind on their real estate taxes, or people whose homes that are being foreclosed on? Isn't there foreclosure lists all over the place? How is this legal? This publication is harassing you. It is oppressing you, and it's abusing you. They're trying to collect the debt, so they're going to take your personal, private, non-public information and broadcast it for the world to see, to make you feel harassed, abused, oppressed, or abused, so that people can point the finger at you and say, well, they can't pay their bills. How is any of that? It's not legal. Congress wrote this to protect us from harassment, oppression, or abuse. Okay? These lists are all over the place. So you do know that these people can be sued for publicizing your information, right? Okay, what does number 4 say? The advertisement for sale of any debt to coerce payment of the debt. Don't they publish foreclosures in the paper in some counties? When you purchase a tax lien that the county makes available for you to purchase, they make tax liens available for third parties to purchase. Isn't that an advertisement? An advertisement? Yeah, that's what it is. Number 5, we know this one very well. We know this one very well. And it's so funny because debt collectors, it's not just debt collectors that do this, causing the telephone to ring or engaging in any person in a telephone conversation repeatedly with the intent to annoy. I get phone calls like that from recruiters. I'm like, why are you calling me back to back to back to back like this? You're trying to recruit me for a job that I'm not going to take. Like, that makes no sense. Like, I've literally had recruiters do that to me. It's crazy out here. People think that they could just do whatever they want to do to you, and they can't do that. But we know that this is probably one of the more popular ones that we know. Causing the telephone to ring or engaging any person in a telephone conversation repeatedly or continuously with the intent to annoy, abuse, harass any person at the called number. So I think there's a law out there that, I mean, this is the law, but collection agencies use different technology that ensures that they do not call a telephone number more than once in a day. I don't know what it's called, but I know it's out there somewhere, right? So this is something that they cannot do. They cannot call you repeatedly. They cannot do any of these things because it's considered harassment or abuse. It's harassment or abuse, right? And so if you all are in a situation, where these people are coming after you and they're coming at you hard for whatever it is that they're saying that you owe, keep this code in mind. 15 U.S.C. 1692 D, harassment or abuse, right? And the law gives you the verbiage that you can use against them. You are threatening me. You are threatening to ruin my reputation. You are threatening physical harm against my property. You are using obscene. The next time somebody calls you, the next time a debt collector, I'm sorry, it's not funny, but the next time a debt collector calls you and try to go in hard on you over the phone, oh my God, you just used obscene or profane language. Why are you being so mean to me? Why are you abusing me? You have to start using big words like that. And so that's going to sort of ruffle their feathers. They're going to be like, I'm not abusing you. You actually need to pay this money. No, you're abusing me. You are abusing me. All right. So yeah, this right here. These three: acquisition of location information. I went over that yesterday. Communication in connection with debt, harassment, or abuse. Now, tomorrow, when I get into false and misleading representations, you're going to be like, what the what? That is going to, when I made the post earlier this week and I said, prepare for your mind to be blown, it's going to be blown 3 times over. It is going to be blown. Let me see if we have anything going on in the comments. Just want to make sure that you all are receiving this information. Hi, Princess Margaret. Hi, Shamar. Thank you for joining. Thank you for joining. I hope that this information was useful for you this evening. I hope that this is, just sort of, and I'm trying to go slow with the information. I don't want to bombard you. I don't want to overwhelm you. Like I said, I'm just here to provide clarity. I'm not an attorney. I do not provide legal advice. My job is to come and provide clarity surrounding consumer law so that you can take and use that information to your benefit, and you can know what your consumer rights are. So again, I hope this information was useful. And don't forget to share this broadcast out so that it reaches the people that it needs to reach. Thank you all so much for joining this evening, and I will see you all again tomorrow. Same time, same place. Peace and blessings, everyone. Bye.